Welcome back to the Collaborative IEP podcast. I'm Ashley Barley, your host, and I am so happy you are here. So, I know that most of you do not look at this, but I also think it might be annoying when I talk about the background or the people, but this one you're gonna like because, we like to say perfectly imperfect around here. And so it would have been really easy for me to have cleaned up the Lego or the pile of pillows or the absolute disaster that is on my dining room table behind me. But I didn't. And you know why I didn't? Because I don't want for you to think that your disaster in your dining room is abnormal. We here believe in the perfectly imperfect. You gotta get stuff done, ladies and gentlemen, and sometimes getting stuff done means that your car or your dining room table or your entire universe is just going to be upside down, and that's okay. It is IEP season, and we got a lot going on. So before we dive in today, as you know, my goal today for us is to finish 1415. I hold it here in my hands. It is a little less than 5 pages printed. So I have every bit of confidence that we can do that. I actually have the rest of section B in my hands over here, and I estimate that we should be able to do that in 2 more episodes. So I'm pretty excited about where we are heading here, and I really enjoyed this trip through IDEA, and so it's been great fun. What I want to talk to you about is summer offerings. So, you probably saw that on my consulting, essentially, I am doing my consulting work at a discount this summer. This is kind of twofold. First of all, when I stopped doing divorce work and small business work and all the other things that I used to do, my job became much more seasonal. And while I always have a few things to like carry me through the summer, I like to work. One is because I have a little bit more time in the summer. And the second reason is because I get so much intake in the fall, and it's stuff that like I could be doing in the summer. We aren't like troubleshooting problems that are happening right now. It's more like things that have happened over time. And I'm like, gosh, if we could do some of that over the summer, then we could hit the ground running and we could even request IEP meetings that week before school starts when teachers are there and they've got 2 hours for an IEP meeting. Um, and so there's a lot of motivation for that. Also, if you are looking for some kind of big argument, like if you need to make a big argument for more inclusive services or for a specific curriculum like Orton Gillingham or, multisensory math or something like that, I can help you at the start of the summer to curate summer planning such that you can strengthen your argument when you go back to school in the fall. So we can really take advantage of the summer months with some of those advocacy pieces. So if you're interested in that, hop over to the website and the collaborativeiep.com. I think it's /consulting, but just go to the consulting tab and you can learn more about that. So let's pick back up in 1515. I think I just said 1515. And of course, you know that the section is 1415. And 1415, as you know, is called procedural safeguards. So we have worked our way from subsection A to subsection I. Subsection I is administrative proceedings. So we're talking about due process procedures. So in subsection I, administrative procedures, we have worked our way down to subsection 3. So we are in 1415 I3, which is called jurisdiction of district courts and attorney's fees. This is a really important section. And then we will so we've got under 3, we've got A through G. Then we're going to come back out to just our normal 1415, and we're going to finish with J through, I think, how far do we go here? O. So we don't have a ton more to finish by way of our topics. So let's get into then what we know about jurisdiction of the district courts and attorney's fees. So 3A indicates who has jurisdiction. And basically, you got federal courts and you got state courts. And what it's saying is federal courts have jurisdiction because of federal question. And you don't have to have a certain monetary amount in order to go to the federal district court. Then award of attorney's fees. You have probably heard this and you might want the specifics. So the prevailing party, the person that wins in a due process case, if it is the parent, then the district has to pay the fees. So what it says is that the court in its discretion can award reasonable attorney's fees as part of the costs. And subsection A says to the prevailing party who is the parent of a child with a disability. What this means in practicality is that if parents win at due process, all they have to do is open a case in district court in the federal court system, and then if attorney's fees get paid in district court. They oftentimes don't get paid in full. There will be some whittling down and scrupulous supervision of those attorney's fees, but attorney's fees get reimbursed or get paid. And this is why you'll see a lot of attorneys that take cases on contingency. It's not a contingency like in a car accident where, the attorney might get a third of the proceeds or something. A lot of times attorneys will say, I'll take your case. You don't owe me anything in the beginning, but if we win, then the school district has to pay your fees and we'll just simply file this district court case in order to get those fees. But what you might not have known is that both the parent's attorney and in some cases, the parent themselves also might have to pay fees. So if the school district or the state Department of Ed win a due process case against a parent, then they can ask the attorney for the parent to pay attorney's fees if the cause of action is frivolous, unreasonable, or without foundation. Or if, as litigation goes on, the attorney keeps pursuing it and it's frivolous, unreasonable, and without foundation. So that's a big risk for attorneys, right? We don't want to file frivolous lawsuits. They also can ask for parents to pay fees if the purpose of filing is improper in the law, such as to harass or cause unnecessary delay or to needlessly increase the cost of litigation. And so, again, we have to really kind of watch the way we do things. Then there's something about the District of Columbia Appropriations Act. Okay. So now we can bump back out to I3C, which is the determination of attorney's fees. And basically it says that they're going to use rates that are prevailing in the community in which the action arose, which is pretty common. A lot of times you have to hire an attorney to come in and testify as to the reasonableness of your fees. Interestingly, I'm in COPA, which is kind of like a trade organization, honestly, like attorneys, advocates, and parents all belong to this organization, which provides immense support to us and is a phenomenal organization. One of the things that COPA doesn't allow us to do is to talk about our fees because of antitrust laws. If we talk about our fees, then, they're worried about price fixing and monopolization and violation of antitrust, which is really, really smart. But I'm always like, well, gosh, I wish we could talk about our fees more because I'm really curious as to whether or not my fees are reasonable, right? So like, where's that line? I don't know the answer. I have to go on what friends in similar parallel areas charge because I don't have a ton of people in the state of Kentucky that practice in special education where I can have these discussions and that sort of thing. You also can look at the district court cases that have been on fees to look at fee schedules. And that's what I did when I first got started because I was like, I want to make sure that I'm charging something reasonable. And if you're too low, there's also another thing about this. You don't need to know this as parents primarily, but if attorneys are too low, then you'll undermine the work of other attorneys in the field, right? So I used to belong to a collaborative divorce network. And when I took my first case, the other attorney said, what do you charge? And I told him, and they were like, would you mind charging $100 more per hour? Because, in a collaborative case, like we all have to be really honest about money and that kind of stuff. And attorney's fees might come up and my client might be really, really mad that they have paid, if they paid $10,000 and their spouse has only paid $5,000. And I was like, well, sure, never. That won't be a problem. Okay. And then there are some restrictions and nuances with attorney fees, and it's a little convoluted in order because I assume because these things came in lots of amendments. And so I'm not going to give you all of the subsections because otherwise we'll go from A to G back up to B and we'll all be confused. But I am going to give you these nuances because they're important. So the first one is there's this federal rule of civil procedure by the number 68. And Rule 68 has to do with offers of settlement. In the case of due process, what happens most often and kind of like in practicality is if you get an offer of settlement arguably within 10 days of the hearing, maybe offer a settlement period that's beyond 10 days, and you reject it. And then that offer of settlement is as good or, not even as good as what you got at trial. In other words, like you should have taken the offer. Then you don't get attorney's fees for that time period after the offer of settlement because they're like, attorney, you should have done a better job advising them to take that offer. So that has to do with Rule 68. There is an exception to attending IEP meetings. Attorneys do not get paid for IEP meetings. And so that is out of there. And then there is a provision about meetings conducted relative to attending hearings and like either judicial hearings or administrative hearings. And let's see. Oops, I did it. I didn't go. I'm going in order instead of doing all the exceptions. I'm sorry. We aren't recording again. So if the Rule 68 thing happens, but parents were justified in rejecting the offer, then you might be able to get your fees. So basically you can argue through all of these nuances, and school districts can too. So school districts can say like, no, we didn't negotiate that way because of blah, blah, blah. And then they give us a nice little thing about how they reduce attorney's fees, which it's a little repetitive. They look at if you protract the proceedings, if you make them too long on either the parent side or the school side, if you're, kind of authorized or if it makes sense for you to have acted the way that you did for some reason. So these things are really, really fact-based. And then it goes into the prevailing cost in the community, the attorney's skill, reputation, experience, etc. And that will take us to J, which is called maintenance of current educational placement. In other words, stay put. And of course, we all know about stay put. So what does stay put mean? I'm going to read it to you because it's such an important part of due process proceedings. During the pendency of any proceedings conducted pursuant to this section, unless everybody agrees otherwise, the child shall remain in the then current educational placement of the child, or if they are applying for their initial admission into a public school, shall, with the consent of the parents, be placed in the public school program until such proceedings have been contemplated. So if you file, you get to maintain your educational placement at that time. That is really, really helpful. So, stay put keeps us in an educational placement. You can agree around it, but a lot of times, especially if we're, filing basically for placement, this is horrendously helpful. So that is subsection J. It's a standalone. That's all you got in subsection J, which takes us to K, which is placement in an alternative educational setting. And K really has to do with alternative educational settings for kids that have had a disciplinary matter. So basically, under K, what it says is first, under 1, these decisions are made on a case by case basis. Under 2, it says that schools can remove kids to alternative educational placement for up to 10 days, even if they're on an IEP. Parenthetically, to the extent that those alternatives are applied to children without disability. So if you can do that to, the kids that aren't on IEPs, then you can do that to kids that are on IEPs. But You have to have an MDR at 10 days, and that's coming. That's the next provision. You have to have that manifestation determination review. And so C is called additional authority. And C says that if the school personnel seek to order a change in placement that would exceed 10 days, they basically only can do that if the MDR is held and the student's behavior is not a manifestation of their disability. Um, so in that case, then they can put them in the alternative setting. If it's not a manifestation, then they can put them in the alternative setting for longer than 10 days. And then D, of course, says if they go to an alternative placement, they get to have their IEP services. So they continue to receive educational services as provided herein, and they also get a functional behavioral assessment, behavior intervention services, and modifications that are designed to address that particular behavior that ended them up in the alternative placement. So then that takes us to E, manifestation determination. And what happens in an MDR is if a student has been removed for 10 days or more in the aggregate for the entire school year, then they are entitled to something called this manifestation determination review, wherein the IEP team get together and determine whether or not the behavior or, plural behaviors that got us to 10 days were manifestations of that child's disability. It indicates here in subsection E that the LEA, the school, the IEP team, all of those people have to review all relevant information in the student's file, including the child's IEP, any teacher observations, and relevant information to determine A and B, if the conduct was caused by or had a direct and substantial relationship to the child's disability, or if the conduct in question was a direct result of the school's failure to implement the IEP. Either of those will say, yes, it's a manifestation and you get to go back to school with certain exceptions. And then B, if it is a manifestation of the child's disability, then the IEP team has to determine that, oh, I'm sorry. Yes. So 2 is just yes. If they say yes to either of those, then it's a manifestation of their disability. F, subsection F now is where we talk about whether or not what happens if it was a manifestation. So the title of F is called Determination that Behavior Was a Manifestation. So if behavior was a manifestation, then it says the IEP team shall. And remember, we all know about how important these verbs and the semantics are, right? So shall, they must. This is what they have to do. And we have 1, 2, and 3. So 1 is conduct a FBA and implement a BIP, a behavior intervention plan, as long as they hadn't done one before. If they've done one before, they're off the hook, but they should review it. And most states that I have seen, it says or review it if it already exists. Then number 2 is if there has been a BIP, review the BIP. That's why. I should have read ahead, and modify it as necessary to address that behavior. And number 3 says, except in a certain circumstance, they must return the child to the placement that they were in before, unless there's some agreement relative to a change of placement. I think I agree to a change of placement. I do agree to it more post-pandemic, and I have agreed to it one other time. So before the pandemic, this was really rare that we would do it. But now I do it a lot, especially if we're close to the end of the school year and it's like review and exams and state testing and that kind of stuff. And I also do it a lot if a child's moving on to the next school. So if it's middle school and they're going to high school, if it's elementary school and they're going to middle school, I'm like, can we just put them at home and ride out the school year and then get to the new school? And what can we do over the summer to ensure that we have a good start at the beginning of the year? The reason why I think this is more common at the beginning of the school, since the pandemic, is because I have a lot of kids on my caseload that are struggling with coping skills and struggling with demand and social skills and things like that. Like actually being in society is really difficult for them. And so um sometimes we have to do, like I always say to my clients, health over education. So sometimes we need to go and really hit hard with outside therapies or with push-in services from school on home placement, get some counseling services in place, get some behavior intervention in place, and then come back to school and see if we can have a fresh start. So sometimes I always say we have to make the closet messier before we go back to school if we want to set a child up for success. Now, that is definitely not my default. My default is kids need to be in school and schools need to accommodate them. But more and more often, I am finding that sometimes we do agree to a change of placement, even when we find something's a manifestation. If that's something that you're looking for, I highly recommend saying that at the beginning. One of my advocacy tips is bold statements, right? So I sometimes will go into an MDR and say, hey, listen, this is obviously a manifestation because of blah, blah, blah. But just so everybody's on the same page, we know that you're recommending that the child go home. And we might be okay with that under these circumstances for this reason. So let's go through, let's have a really good conversation and just kind of know that we're all like maybe thinking the same thing. And then you aren't predetermining, but you're kind of like setting this boundary and you're making this bold statement, right? So I think that's really helpful. What are the special circumstances where where the discipline can result in behavior that's a manifestation of the child's disability, but they still can change their placement? It's what you think it is. So we find those in G. Carries or possesses a weapon to or at school, on the school premises, or to a school function. Number 2 is knowingly possesses or uses illegal drugs or sells a controlled substance while at school, on school premises, or at school function. Or number 3, has inflicted serious bodily injury upon the person while at school, on school premises, or at a school function. So that's what you would think. And then H is the notice provision. Number 2, then, so that was K1. And now we're going back out to K2, which is determination of the setting. And basically, the alternative educational setting is determined by the IEP team. So, if we're going to a more restrictive setting, are we going to like in school suspension? Does the school have an alternative school? Do we need to go to an alternative school that's offsite? Do we need to go to a home placement, even hospitalization, something like that? And then 3 gives us an appeal provision. So if the school recommends an alternative education setting because of a disciplinary matter, then the parent can appeal that. And the way you do the appeal is you request a hearing. And then basically there can be 2 outcomes. The hearing officer can either return them to their old setting or they can do a 45-day placement if the hearing officer determines essentially that that's appropriate. So they can do the interim placement for 45 days. So long as they think that maintaining the current educational placement would cause, what's it say, substantially likely to result in injury to the child or to others. So that is what happened. And then we move out to subsection 5 under this provision. So the next thing we get is a provision that I use really often, but I don't think will probably apply to many of you because if you're listening to me, then you probably already have a kid on an IEP. But you can also follow this same procedure for students that don't have disabilities at school, are not on IEPs, but should be on IEPs. So basically, if you can prove that a child should be eligible for special education or should be suspected as being eligible for special education services, you can force an MDR in their circumstance as well. So when I get intake for discipline, my first question is, are they on an IEP? If the answer is no, that's not a dead end. You can still force an MDR by, I normally just request an evaluation in the beginning of the special education process, and then we go through the MDR provision. The only exception to that is when the parents have kind of gone down the eligibility process and they have denied an evaluation. If they've denied an evaluation for any reason, then the school doesn't have to do an MDR because the school can be like, well, we tried and you declined it. I've only run into that one time and the school or the parents declined MTSS or RTI. And I was like, that's not technically an evaluation. We had to go deep into the argument of what an evaluation was. And they were like, fine, we'll do the MDR. And that student, I don't even remember what happened if we put him on a 504 and IEP after that, but at least we got that far. So that's a super helpful provision. I just don't know that it's going to help you all that much. So we're going to move on to number 6. And number 6 is an indication that the school can then refer the child to legal authorities, which totally makes sense. So law enforcement and other judicial authorities can get involved if students have, if they violated the law, right? So because we're talking about threats, bodily injury, drug and alcohol use, and weapons, then of course schools can refer that on to the appropriate agencies. If they do that, schools have to ensure that special education records go over to the authorities and that the disciplinary records go over to the authorities so that they get the entire record. And I do see that a fair amount where, the court designated worker or the prosecutor doesn't have a copy of the IEP and the evaluation reports and that kind of stuff. And I don't do a ton of criminal work. Sometimes I do these cases. And, there's 2 elements to the crime, like the crime itself, right? Like kidnapping has a kid and a napping. Those are the 2 elements. But then you have to have intent to kidnap. And so a lot of times this kind of comes into intent. Like, were they capable of intending that? Did they know what they were doing? That sort of thing. So it's really important that the special education records go over as well. Subsection 7 gives us definitions of controlled substances, illegal drugs, weapons, and serious bodily injury. And I think all of those go out to definitions in other parts of the federal law. So we won't go into that. And then and then that's all we have on alternative placement in disciplinary matters. So now we have L, M, N, and O, and it's really just kind of like catch-all things. So L says, hey, none of this stuff in section 1415 would prohibit somebody from filing lawsuits and complaints and proceedings as they apply to the Constitution, the ADA, Title 5 of the Rehabilitation Act of 1973, which is section, or any other federal laws that protect students with disabilities and children with disabilities, except, and here's the big thing, because there's a huge exception. It says, except that the procedures that are elaborated in section 1415 have to be exhausted first. And there is a whole body of law on exhaustion. But the thing that's important to know is that you have to exhaust your administrative remedies before you file a federal lawsuit. So basically, when in doubt, file due process. That is the easiest way to go about it. There's all kinds of cases where you don't have to exhaust and where you do have to exhaust. And when I go to COPA, I go to all of these things on exhaustion. And then I think, oh, heck, I think you would just file due process anyway, except in like very, very specific circumstances. And if and when that does happen to me, I definitely phone a friend because it is extremely nuanced and complicated. Okay. But that's basically your exhaustion. M, transfer of parental rights at the age of majority. Super duper important thing for students who are, reaching the age of 18, transition age, and what happens. So basically what happens is when students reach the age of majority, which in Kentucky where I practice law is 18, then any rights that are assigned to the parents go to the student. That's the default. So the student then becomes the decision maker, and the student and parent rights become student rights at the age of 18. Now, if the student is deemed to not be able to make decisions for themselves, then the school has to have procedures in order to keep the parents as the decision makers of record. So that's the way that works. Schools are required to advise you of guardianship, and so I think a lot of families go down the guardianship path because being advised of it and being recommendation must be like a hard line for schools to understand, because a lot of schools just recommend guardianship, but that is definitely not what IDEA says. It doesn't say to recommend it. And in fact, IDEA says that at the age of majority, the kids get the parent rights unless they are unable to make decisions for themselves. And we have 2 more provisions in electronic mail. So any notice provisions can go by email, and separate complaint. Nothing in this section shall be construed to preclude a parent from filing a separate due process complaint on an issue separate from a due process complaint already filed. So you can have 2 going at the same time. That, my friends, is section 1415. And we are going to start up with section 1416 next week. It is called Monitoring, Technical Assistance, and Enforcement. It's a little boring, so I am going to work to summarize it for you so we don't go provision by provision. I will see you next week, same time, same place.